So I said the course for this semester will expose us to general introduction to the judicial system in Nigeria, and it will equip you with knowledge as to how we have evolved as a people. And then we will look at how the system functions and also the processes that are involved in how our judicial system runs. And then at the end of the class, it will be expected of every student to have gotten at least a general idea of how the Nigerian legal system functions. Of course, the good thing about it is that some of us that were here, we already have an idea of how our judicial system runs. But this course will enable us to put it into proper context, so that what you used to know, you will understand it in the right context. So that means in the course of this semester, we'll be looking at 7 topics. JI 1, 2, 2. The course content, we're going to be a total of 7 topics. And the first one will be role and function of the judiciary. The role and function of the judiciary. Under that topic, our focus will be on Section 6 of the Constitution of the Federal Republic of Nigeria. And that is the section that provides for judicial powers in our country. And then, under that section, we will see the role that the judiciary is expected to perform. Apart from the role, we will also we will see the various functions that the judiciary as an entity or as one of the arms of government is supposed to do. Like I said earlier, some of these functions are what you already know. So we will look at these particular functions and also the roles. And one of the things we will also do in the course of looking at that topic is to be able to distinguish between the roles and the function of the judiciary. So that when you look at the core role of the judiciary, you will be able to separate it from the functions. And then we will also look at the powers that is vested in the judiciary. One of the things that should interest you is the fact that when the governor of a state and the legislative arm, they are having a problem, they will drag themselves to where? To court. Dragging themselves to court signifies that, yes, the governor or the executive arm is more or less the controlling body, yet it does not have the total control without checks, or it does not have overall control over the judiciary, over the legislature, and all of that. If it were so that the governor is the all-in-all, once there is an issue between the executive arm and the legislative arm, the governor is just to wake up and say, what I've said is superior, right? And that will be it. But you will notice that it doesn't happen like that. Rather, they drag themselves to where? To the court. And when the court decides, whatever the court decides is what they take as what? As a final decision, especially if it has to travel from the either the High Court to the Court of Appeal and then to the Supreme Court. At the end of the day, once the Supreme Court has given a verdict, it will be seen that that is the judgment of the court. Therefore, the parties will do what? We abide by it. Now, that signifies the fact that the judiciary is not just a mere body, but it's a body that possesses power to adjudicate between either the different arms of government or between government and the citizens, or between citizen and citizens, or between a citizen and an entity, maybe a company, as the case may be. So under this topic number 1, we are going to deal extensively with the function of the judiciary as well as the role. So for topic 2 will lead us to the traditional system for dispute resolution. That's another area we are going to delve into seriously. Traditional system for dispute resolution. One of the things you will probably know before now is that in our formative stage as a country, there was nothing like the High Court of Lagos. There was nothing like the Supreme Court, isn't it? We had a system where the obas, where the chiefs in council, where the bailiffs, where the obis, where the emirs do what? They manage disputes between the citizens in their community. Unlike today, some of us we live in a community, we don't know where the bailiff's palace is. But then anybody here who knows where the bailiff's house is, where they live. And some of you live in Abuja, right? You probably don't know the bailiff's house. But at the early stage of our development, those were the bodies that stood to administer justice in the community. So that's this topic number 2. We center on the different methods of dispute resolution mechanism that we have. We'll talk about that. We'll talk about the sources of conflicts. What usually lead to conflicts in the society. Then also we'll look at the various characteristics of our indigenous conflict resolution mechanisms. Meaning that if we identify a particular method, we will look at the features or the characteristics. So therefore, we are going to have introduction to the source of conflict in indigenous African society. We will look at the features of the various institutions that administer justice in the society. And then we will now look at the various methods, which include number 1, the negotiation method. Number 2, we will look at the arbitration method. Number 3, we will look at negotiation method. Okay, we will look at arbitration method. I've said that again. That means you are following me. Then we will look at adjudication method as well as reconciliation methods. All of these are the different methods that we have in resolving conflicts. We're going to look at them under that topic. Now, when you are looking at all of these things we're talking about, of course we mentioned reconciliation method. One thing that comes to your mind is that why do we need all these methods as a form of dispute resolution mechanism? The simple truth is that whether we like it or not, there will be dispute between individuals in the society. Am I wrong or correct? Yes. There are people in this class now who are fighting themselves. Right? Before, they used to sit like this. One is now on that side, the other one is now. If you find out what are the likely causes of their dispute, what can be the likely causes? What? Money. Money is something that is God created special. Some of you will borrow money. You will know what? You will not pay back. And when the owner is now asking, he say, where is my money? The next question you will now hear is that, how much is the money said? You see, those people that just laugh now, they are the people that have done something like that. So, and a popular adage says that there is no way you can walk and your head will not shake. Abi? If you interpret it to the point that there is no way you want to live harmoniously in the society where there will be no conflict. So consequently, there will be need for conflict resolution. Okay, so that's why we're going to take our time to look at the traditional system of dispute resolution in Nigeria. The third topic we are going to look at in the course of the semester is the history of the Nigerian judicial or court system. The history of the Nigerian judicial or court system. In that case, we will look at the pre-colonial justice administration. How did we manage when we were not as sophisticated as we are now? In those days, when there are issues, people go to the shrine, right? Because if you gather them on a normal day and ask can you tell us what the issues are? One of them can be telling lies, and yet it will be saying it as if he's saying the truth. Some of you know what we're talking about here. But when you carry them to the Amadioha shrine, as they are going there, they are already made up, they're going to make up their mind to what? To say the truth. Don't say the truth. Amadioha will do what? We do what? We strike you, Abi. Amadioha will strike the person. And one way or the other, that was a form of court in those days. I actually saw a skit where a neighbor alleged that somebody stole his chicken. And everybody in the house, just like some of you, will just deny. He said, no, some will say, I've not even seen that chicken. I don't even know you have a chicken. Not to talk of whether knowing the color or whatever. So after the man has shouted all here and there, nobody was willing to own up. And then the man said, okay, that he was going to see an herbalist who is going to unravel the mystery behind the sudden disappearance of his chicken. So the one that stole it knew that there's no way that this thing will not reveal who actually did it. So he allowed the man to leave the house. Himself went somewhere and carried his phone and now called him and say, what is your problem? Can't we even play with you again? He said, can't somebody just play with you? Now you want to go and meet the DPI, you want to go and, we are just playing with you, come and take your... Because if you should allow him to go, what will happen? The people in the shrine will either reveal who took the what? The chicken. So in those days, as a matter of fact, it appeared that our society were, more organized, or they were like afraid to do what was wrong. Unlike now that you have done something bad, especially those who get themselves involved in maybe election issues. After they have rigged themselves in, they will go and hire SAN to do what? To defend them. Lori Ro, is that not how we say it? You hire 10 SAN to defend you, even when you know that the election that brought you into power is what? Was rigged. But in those days, when they say, okay, carry the iron and say that your election was not rigged, I'm sure it will not even go. You will not go there. So, we will look at how we started at that primitive stage. Then thereafter, we will look at the judicial system under the British colonial administration. We're talking about the colonial era. How was our judicial or court system at that time? Then after that, we will look at the post-colonial development in Nigeria judicial or court system. The post-colonial. One of the things that you will have noticed from this submission is that this particular topic we are introducing is going to be divided into how many? Into three. The first one will be the colonial era. The second one will deal with what? The colonial era. While the last one will do what? Will deal with the post-colonial. All of these three stages will be examined critically, and then it is expected that we are able to identify the various features, identify or that were peculiar to the various era in our judicial time. Thereafter, topic 4 will be on the structure of the court system in Nigeria. The structure of the court system in Nigeria. Our emphasis there will be what kind of structure do we have that makes our own judicial system to be unique, different from other countries or jurisdiction as the case may be. Then we'll move on to look at meaning of courts and classification of court. as topic 5, meaning of courts and classification of courts in Nigeria. Under that topic, we will look at superior and inferior courts. We will look at what? We will look at courts of records and non-courts of records. Courts of records. Record as in R-E-C-O-R-D. Courts of records and non-courts of records. The first one is what? If you did not hear it, you better speak up because you are not saying what I mentioned. The second one. And the third one we are going to look at is courts of limited and unlimited jurisdiction. Courts of limited and unlimited jurisdiction. Courts of limited and unlimited jurisdiction. Now, again, we will also look at English and non-English courts. English and non-what? In bracket, you can put customary and non-customary courts. Customary and non-customary courts. Then we will also look at another set of courts known as courts of original jurisdiction and courts of appellate jurisdiction. Courts of original jurisdiction and courts of appellate jurisdiction. If you don't know the spelling of appellate, ask your neighbor. Of course, this is not an exam, so feel free to ask. Lastly, on that, we will look at federal and state courts. Federal and state courts, and the last but not the least of those courts is the special courts. The what? So we have mentioned superior and inferior court as a topic or as a subtopic. Courts of records and non-court of records. Courts of limited and unlimited jurisdiction. English and non-English courts. Courts of original and court of appellate jurisdiction. And federal court and state court. And last, special courts. And by the time we are done with that, we move to topic number 5. Topic number 6, which is establishment, composition, and jurisdiction of Nigerian courts. Establishment, composition, and jurisdiction of Nigerian courts. Under that, we will look at the various formations, how we come about the existence of these courts. What portion or section of the Constitution established a court? And then when we talk about the composition, we'll talk about the number of judges that can sit there, what their constitution must be, or the number of years subject that they must have attained as a legal practitioner before they can be appointed as a judge, or who does the appointment. All of those are the subjects that we will be looking at under this topic, which is the establishment, composition, and jurisdiction of courts. And these courts that we'll be focusing on include: 1, customary or area courts. Customary or area courts. That's 1. Number 2, magistrate courts. Number 3, state high courts. Number 4, national industrial courts. Number 5, federal high courts. Number 6, customary and Sharia courts of appeal. Number 7, court of appeal. And the very last, the Supreme Court of Nigeria. So, we're going to look at the laws establishing them, the composition, the kind of cases that they can determine or that they can hear. All of that will form the subject that we're going to look at under that. And the last topic for the semester will be special courts. Special what? And these courts will include administrative tribunals, juvenile courts, military courts, and lastly, Sharia courts. Under special court, like I said, we'll be looking at administrative tribunals, juvenile courts, military courts, and Sharia courts. What are the recommended tests for this course? Number 1 is the Nigerian Legal System by Akintunde Obilade. I think we shared this particular test in during our first semester. So if you already have that, you are good to go. The second one is Introduction to Nigerian Legal System by John O. Aseyin. Aseyin is spelled A-S-A-I-N. Aseyin. Then we also have another recommended test, Sources of Nigerian Law. Sources of Nigerian Law by Nikki Toby. Nikki Toby, N-I-K-I. The title of the book is Sources of Nigerian Law. And the last one is Osita Ogu, with the title of the book Modern Nigerian Legal System. Modern Nigerian Legal System. So if you have all of these books, you are good to go. And the reason why we have dealt, thoroughly with the course contents in this course, Introduction to Law of the Nigerian Legal System II, is for you to be able to prepare ahead of our classes. Of course, if you do your studies on your own, it will be very much easy for us as a class to do what? To move forward and faster with better understanding. Okay? So this is the end of the introductory class for the second semester of this course. I don't know if there is any question relating to what we have done so far. We'll be available to answer the question. Any question? Any? All right, so we bring the class to a close today. And